Hi guys, AJ here again and welcome back to Contract B. This week, week 3 of our course, we're going to be looking at estoppel, and perhaps in some contradistinction to weeks 1 and weeks 2, estoppel is a nice little topic to get your mind across. The principles are all fairly straightforward and they make some fairly good common sense as well as conscionable sense. So let's have a look at the development and the principles and remedies associated with estoppel. I've done this presentation for you. I will try and pop it up onto the website for you in case you want to look at it later. But it kind of fleshes out for you most of the salient points that you'll need to know. Okay, first thing to note is that there is a little beastie called estoppel at common law, and it's called estoppel in Pais or estoppel by conduct. In terms of what it actually does and the elements that it needs to have satisfied, it kind of runs parallel to equitable estoppel. The big difference is what you can actually get at the end of the day if you're successful in raising an estoppel at common law. So it prevents a person from unjustly departing from an assumption of past or existing fact, okay, tick, which the other party has relied on, tick, that's also required in equitable estoppel, which will cause detriment if resulted from. So, yep, that's also a requirement of equitable estoppel. However, and here's the big difference, common law estoppel is only a rule of evidence, okay? So it just dictates what can and cannot form part of the evidential base that the court considers in making its decision in the case, okay? That's really all it does, okay? So where someone's trying to plead something and rely on their strict contractual rights in circumstances where those elements have been satisfied, they're not going to be able to, okay? So really it's not a cause of action in itself. It just dictates what can and can't be brought in as evidence. That's common law estoppel, fairly limited. Okay, then we have our wonderful equitable estoppel, far more flexible, far more friendly, and it really does do quite a bit in terms of augmenting the general principles of contract where they would otherwise operate quite harshly. What happened was a couple of 19th century cases started in a very rudimentary way to flesh out the dictates of equity in these kinds of situations. I'm talking about the railway cases here, Hughes and Metropolitan Railway and Birmingham and the North Western Railway Company. In both of those cases, what you had in terms of the fact scenario was a contract that was already on foot, and then the parties had negotiated in relation to some aspect of the contract. In Hughes and Metropolitan Railway, it was that some repairs had been required to be done by the landlord. They had given the tenant notice that they needed to conduct some repairs within, I think it was 6 months. In the Birmingham case, there was some time provisions in the contract, and it was agreed that those time provisions didn't have to be met whilst the building contract in question, the building works had been suspended. So both cases there was a contract, both cases there was time stipulations, and both cases, while the negotiations were going on in relation to the timing issues, a person had failed to act to fulfil what would otherwise have been the fairly strict contractual terms in relation to time. And so they would have suffered detriment if the defendant was able to go back and then enforce their strict contractual rights in relation to those time periods at the end of the day. And that's exactly what the defendants tried to do in both of those cases. After the negotiation went on and the other party had relied on the fact that these negotiations were going on, didn't fulfil their obligations within time, then the defendant tries to say, hang on a minute, you didn't fulfil these time obligations. Court says, look, no, the plaintiff didn't have to do that at all. The plaintiff is quite right in asking us to prevent the defendant from enforcing their strict contractual rights against you as the plaintiff. So from those two cases, we had the following principles. If the parties entered a contract and then negotiated, where the effect was to induce one party to believe the other party wouldn't enforce their strict contractual rights, that party wouldn't be able to then go back on its word when, in all the circumstances, that would be inequitable conduct. Okay, so then we have the landmark High Trees case in 1947. So Equitable Estoppel had kind of gone to sleep from 1888 to 1947, more than 50 years, and then it was revived in a rather spectacular fashion and expanded. What you had here was a block of flats that was leased to a tenant, and this tenant was to pay ground rent for all of the flats in this block of flats, and then the tenant was going to sublet those flats to subtenants. That was all fine, worked well for a period, but then World War II hit. The flats were not fully let, and the problem for the tenant was that they couldn't afford to pay all of the ground rent out of the profits that they were making from the few flats that had been still let in this block of flats. And so the tenant did the right thing, went to the landlord and said, look, I'm having problems, I can't pay this ground rent, what are we going to do? And the landlord made a fairly serious concession and it said, look, that's okay. I will agree with you that you can pay half of the rent that would otherwise be due indefinitely, because obviously no one knew when the war was going to end. When the war did end, of course, the flats became fully let again, and the tenant kept paying its rent but at the reduced price. Subsequently, the landlord sued for what was essentially back pay. They wanted the full amount of the rent for the entire time that half the rent had been paid by the tenant. So the question was, could the landlord go back and enforce their strict contractual rights despite the fact that there was this fairly serious conversation that went on between the landlord and the tenant? And the court held, not surprisingly, no, the landlord couldn't do that. So if a promise is made, which to the knowledge of the promisor is to be acted on by the promisee, the promisor can't go back and act inconsistently. Now, that was all, it was a fairly landmark case, but the principles hadn't really been analysed and fleshed out. By 1951 and Coombe, we did have a bit more of a fleshing out happen here, and there was essentially 4 elements that were enunciated as belonging to equitable estoppel. So here you have, if one party by words or conduct makes a promise to the other and it's intended to affect legal relations, okay, obviously going to be a fairly serious kind of promise that's being made here. Then it's intended for the other party to act on that promise. The promisor can't then go back and resolve from the promise and try and enforce their strict contractual rights. Now, the upshot of all of this, whilst it was very useful and an expansion of those old railway cases, it was difficult because it was kind of left at half-mast, if you will. Estoppel could really only be, in equity, a shield and not a sword. In all of the cases hitherto, you'd already had this pre-existing contract on foot between the parties, and then there had been a promise, and then there was reliance, and then there was going to be that detriment if the promise was resolved from. So really all that Equitable Estoppel was doing was a little bit like, common law estoppel, in that it just stopped someone from acting in a fashion that was not in accordance with good conscience. So it didn't actually provide a separate source of rights. And here you'll see the text goes on about, the judicial concern at this point to prevent what it saw might possibly be an avalanche of equitable estoppel cases and the subsequent erosion of the very hallowed rule of contract law that you need to have consideration to support a promise in order to make it legally binding. Okay, they thought the whole notion of consideration would be undermined if this whole business of equitable estoppel kind of got out of hand. So yes, at this point it was a shield, not a sword, not a separate source of rights. And then you have the High Court case of Waltons Stores and Maher. Interestingly, just by pure serendipity, it occurred in the centennial anniversary of the last of the railway cases, 1988. And in this case, we had a fairly radical extension of the whole doctrine of equitable estoppel. And in this case, you'll certainly see why from the facts. The owner of land, Mr. Maher, dear old Mr. Maher, had negotiated with Waltons Stores. Now, at this time, I don't know if any of you can remember, but certainly in Queensland, Waltons Stores was a fairly significant force to be reckoned with. It had a number of what we called department stores, those newfangled things, and it was negotiating to lease premises from Mr. Maher. Now, what Mr. Maher was going to have to do under this deal was to demolish, I've got demolished land. It should have been demolish and construct a new building on its land for Waltons. Okay, so there was an old building on the land. Mr. Maher had to knock that down, build a new building for Waltons Stores, a brand new department store, and it was going to be all specced up according to the way that Waltons wanted things to happen. Obviously, this was going to be a fairly significant contract for Mr. Maher. It was going to be worth his while to go to all of the trouble of demolishing the old building and building up, constructing a new building, making it all right for Waltons. So he was kind of at Waltons Stores' mercy a little bit in terms of, I guess, the pressure that Waltons could exert on him. Probably right from the get-go, Waltons indicated to Mr. Maher that, it wanted him to jump when they said jump. They said that they were under a fairly tight time frame. They could only afford for this whole deal to work. They could only afford, a certain amount of time for the building to be demolished, the new building to be constructed, the new building to be fitted out and then ready for trading. So they put pressure and said that they needed everything done on this very tight time frame. Now, obviously, that made Mr. Maher very cognizant of the time stipulations in the contract, and he was at pains to try and meet the time stipulations that were in the draft contract. As I said, there was a draft contract, documents got prepared, and after the documents had been settled, Walton's solicitor wrote to Mr. Maher and said that Walton's approval was forthcoming. Okay, forthcoming. So it led Mr. Maher to think, oh, well, this is just really a formality. The solicitor said that they would let him know if there was going to be any amendments required to the contract in the next few days. What happened then? Mr. Maher didn't hear from Walton's solicitors, and so after a couple of days had passed, no amendments had been requested. He signed off on his copy of the contract and sent it to Walton's solicitors by way of exchange. So here is my executed instrument, and then what Waltons solicitors would have had to have done to form a binding contract was get Waltons to sign off themselves and provide that copy of the contract to Mr. Maher. Then all of a sudden you'd have a binding legal relationship existing. However, Waltons certainly did not do that. The owner proceeded to start with demolition of the old building because, as I said, he was very cognizant of those time frames. Waltons then, they were heading into a bit of trouble in the late 80s, early 90s. Ultimately, they were wound up and they are no more. There is an old Waltons building still in Fortitude Valley if you live in Brisbane and you're of a mind to go and see it. But as a result of Walton's restructure, the decision was made that they didn't want to go ahead with this deal. And they thought, oh, Bob's your uncle. You know, we haven't signed anything. It's all good. We've got no binding contractual relations. They told the solicitors to go slow, but they didn't pull out then and there. Then they knew Mr. Maher was demolishing the old building, and then 2 months later, when the building was 40% complete, they eventually say, oh, actually, sorry, we're not going to go through with this deal. Now, poor old Mr. Maher was obviously left with his jaw dropping and wondering what he was going to do with this 40% complete building that had been all specced up for Walton's department store. So, have a think about what was at issue here. There was no binding contract between the parties. So there could have been said to be no consideration given for any promises that had been made. So, as I say at the last bullet point there, whatever equity did to step in here could almost be seen as tantamount to enforcing a gratuitous promise. So there was a fair bit of caution here, and you can see that all of the judgments are very carefully written because I think everyone was pretty much aware that if they allowed equity to step in at this point, it was going to provide a sword, not just a shield. It would provide a source of rights for Mr. Maher then to claim against Walton Stores when there was no binding contract on foot between the parties first. What was held in that case? Equity will step in to give you relief where the other party is acting unconscionably in ignoring the other party's assumption. And the whole basis, the court said, for equity's relief here, the whole basis of the action in Equitable Estoppel, and it was an action at this point, was unconscionability. And if you think about that and take a step back, if unconscionability is at the heart of Equitable Estoppel, and the whole point of the court stepping in is to prevent unconscionability, then there's no reason to limit it only to being used as a shield rather than a sword. If you've got unconscionable conduct, no matter where it occurs, then equity should step in to provide some kind of relief, whether that's to stop someone enforcing their strict contractual rights where there was already a contract on foot between the parties, or where there was this promise that had been made in very serious circumstances. The other party knew it, the other party intended that the assumption would be relied on, and the other party suffered some detriment. Unconscionability in both cases, no real reason to deny relief in either case. So, Justice Brennan set out what is a fairly famous treatise on equitable estoppel in that case, and he set out 6 elements which have been cited and cited and cited and cited, and you can take it from me, this is good case law. So the first element, plaintiff assumes a legal relationship exists between the plaintiff or expect it would exist, and the defendant would not be free to withdraw from this assumption that had been made, okay? The defendant then induces the plaintiff to adopt the assumption. So they play a part in the other party actually adopting the assumption. The plaintiff acts or abstains from acting in reliance on the assumption. The defendant knows about this. So here's where your unconscionability starts to kick in. And the plaintiff's action or inaction is going to cause them detriment. Finally, the defendant fails to act to avoid that detriment. So that was Waltons and Maher and Justice Brennan's 6 elements. So what we're going to do now is just cover off those 6 elements, kind of flesh out the requirements of each one. Firstly, element 1, an assumption or expectation. So here you need to be very careful on when you're answering problem questions on equitable estoppel. You need to take the time first up to identify what the expectation is that the plaintiff has adopted. Okay? It might be an assumption of fact, might be an assumption of law. Sometimes assumptions of fact and law are pretty difficult to disentangle. So, for example, in Waltons and Maher, was it an assumption of fact or was it an assumption of law? Was it an assumption that the contracts would be exchanged? Was it an assumption that contractual relations were going to actually be concluded by that contractual exchange? So it won't really matter at the end of the day in terms of whether it is an assumption of fact or law if the effect of all of this is going to be unconscionable conduct. Now, Justice Brennan in Waltons Stores said that the element of assumption kind of has 2 limbs. There has to be an assumption or an expectation that these legal relations are going to arise. And secondly, there has to be an assumption by the plaintiff that the defendant won't be able to get away with backing out of that assumption. Okay, the defendant can't resile from their assumption and go back on their word. There has been a bit of debate about that second limb, and the text does talk about that. There was a case called Ostertel and Franklin's in New South Wales, and Justice Priestley expanded on Brennan's enunciation, I guess, for want of a better word, of these 6 elements, but principally the first element. And Priestley said that an assumption can constitute something like a contract will come into existence, so that was the case in Waltons Stores, or a promise be performed, or an interest be granted. Okay, and we'll talk about Ostertel and Franklin's in just a minute. So just kind of note in your back of your head there is an issue about whether or not the plaintiff has to not only assume this kind of state of affairs, they also have to turn their mind to the issue of whether the defendant could get away with backing out of this state of affairs. Obviously, the assumption has to be clear and unambiguous. Okay, equity relieves against unconscionable conduct, and it's got to be pretty darn hard to prove unconscionable conduct where the very heart of it, the representation that kind of induces this assumption, is ambiguous or unclear. Okay, it has been rationalised as being unreasonable for the plaintiff to rely on a representation if it is ambiguous. In some cases, you do find somewhat ambiguous representations being enforced, and these tend to be in familial contexts. There was one in Australian Crime Commission in Grey. I'll leave you to explore the detailed facts of that case at your leisure, but essentially it involved what expenses would be covered in supporting a family that had gone into the witness protection program. And the Australian Crime Commission had promised the family that they wouldn't suffer any financial disadvantage. And the question was, well, how do you unpack financial disadvantage? I mean, when does it stop? Does it stop, are they to be covered for all expenses? Does it stop when they come out of the witness protection program? When, how long after does it stop if it's not to end upon them coming out of the witness protection program? The family had suffered some fairly devastating losses, and I think that probably had some bearing on the court's ultimate decision, but they did find that the family was to be covered in terms of no financial disadvantage for a period of about 3 years after they came out of the witness protection program. So that's the requirement of the representation being clear and unambiguous. And here you come to the case of Ostertell and Franklin's, and the question there equally was whether it was reasonable for Franklin's to rely on the representation that they wanted to rely on. Rather interesting case. In fact, what I will say is that the text tends to give you a little bit of a mistaken impression, no pun intended, of this particular case, because they give you an extract from the minority judgment, and they don't tell you what the majority held. So I will let you know here, and then perhaps you might want to jot that down somewhere in the text so that you know what the case actually decided. Franklin's had told Ostertell that it required Ostertell to fit out the premises according to its specifications, so a little bit like Waltons stores and Maher. Franklin itself spent a fair bit on fit out, and it also was fairly confident that a lease was going to result with Ostertell because it actually moved to terminate the lease on its old premises. Now, Franklin's then negotiated with Ostertell for a heap of additional floor space, and the big, question mark that was left was how much was Ostertell going to ask Franklin's to pay for this large amount of extra floor space. Franklin's and Ostertell never reached agreement on the amount that was going to be paid for that additional floor space. Subsequently, Ostertell needed to finance its activities, and its financier requested that they secure a commitment from Franklin's as a major tenant to the lease. So that would give the financier a little bit more confidence in lending money to Ostertell, because if they've got a big tenant like Franklin's there, they're much more bankable than if they didn't. Interestingly, Franklin said that they would not commit to the Ostertell lease at that point in time. So just bookmark that little fact. Then, obviously, because Ostertell was having difficulties with the financier, they thought, well, let's try and find someone who will commit to a lease. So they started negotiating bylaw to see if they would actually sign on the dotted line. Franklin's then got pretty ticked off that Ostertell had approached bylaw, and they sued to stop Ostertell from backing out of the lease deal. Franklin said, we assumed that the lease was going to result. We've done all these acts in reliance that the lease was going to result. And to the court, please stop Ostertell from backing out now. And Priestley there, as you'll see, expanded Brennan's notion of a qualifying assumption. So what will actually qualify as an assumption for the purposes of equitable estoppel. And Priestley said all you need is those assumptions. Let's have a look here. Where are we? Here. The assumption that a contract will come into existence or a promise be performed or an interest granted. That was what Priestley said that you needed in order to found this first element of equitable estoppel. He did not add the rider that the plaintiff must turn their mind to the question of whether or not the defendant could resile. Okay, there was enough if you had this kind of assumption that had arisen. The extract in the text, as I said, kind of tends to indicate that Franklin succeeded on equitable estoppel here, but in fact they did not. And there was some fairly cracking decision making by the majority judges, I think, here. And what had happened was Franklin's had deliberately, not only had they said that they wouldn't commit to the lease, okay, as I said to you before, just keep that in the back of your mind, they had also deliberately failed to mention this whole issue of the additional rent because they just hoped that they'd get away with the topic not being brought up again. Now, in those circumstances, Franklin couldn't rely on an assumption that a lease would be granted because the rent for the additional floor space, which is, a fairly significant issue, just hadn't been agreed. So essentially what had happened was Franklin's made a deliberate gamble in its conscious decision not to come to agreement on a term, that is the amount for the additional floor space, and they failed dismally. Rogers said for a court to impose a term which one party had deliberately chosen to withhold would constitute a full frontal assault on what is generally required to make an agreement between persons in commerce. And I think that's a fairly robust comment. I mean, honestly, if you've got a party like Franklin's with all its lawyers, all its legal advice, all its commercial expertise, and Ostotel, which is obviously running a fairly significant property business, you've got two fairly hard-hitting parties here. If one is going to take a gamble on, throwing money towards a lease that hasn't eventuated yet, you're going to have to take that into context when you're making a decision about whether or not to apply equitable estoppel. Similarly, Kirby said courts shouldn't substitute lawyerly conscience for the hard-headed decisions of business people. So I think they kind of realise that there has to be somewhat of a reining in here. You have to look at the contextual circumstances surrounding the deal that's being complained of, or the non-deal in this case that's being complained, and you need to analyse what experience the parties have brought to bear, what negotiating tactics the parties have brought to bear, and how that has affected the decision making that went on in the conduct between the parties. Okay, so that is the decision in Ostotel and Franklin. Okay, so here's probably a good time for us to all take a mental stroll, take a breather, and refresh ourselves, and we can come back in a moment for part 2 of Equitable Estoppel. See you soon.